Mr Speaker.
The Honourable Christopher Finlayson.
Thank you, sir. Actually, I thought that Ms Ardern's speech, when she got away from the vituperative comments and concentrated on the bill, was actually a very good contribution. And she raised a number of questions, and her last point I'll come back to in the course of my speech, because I think she's right. This is a very important issue, and I have more than a passing interest in it because I, as Attorney General, am the link between the judiciary and the executive. And we have to accept as a starting point that the judiciary is a separate branch of government. They're not an extension of the Ministry of Justice. And from time to time, there will be tensions which arise between the various branches of government. And this legislation, if it is passed, will, I believe, cross that very important boundary. Now, as between the various branches of government, there will always be tensions. Last session, the Privileges Committee, of which I was a member, looked at tensions that arose actually between the legislature and the executive. One wouldn't expect those tensions to arise, but they did. So there need to be some bright lines there as well. But so the member raises a very important point about the importance of transparency. When someone is sworn in as a judge, one expects that they will do justice and they will be seen to do justice. And if there are allegations about conflict of interest or lack of transparency, then people will walk away from the court feeling that they haven't had a fair go. And so that is a very important consideration. But I do believe, with the greatest of respect to Mr Kennedy Graham, who introduced this bill with the best of intentions, that it is faulty. It would, if enacted, breach that important bright line between the judiciary and the executive, or the judiciary and the legislature, and should not be passed. A little bit of the legislative history is perhaps instructive for the House tonight. When the bill was introduced, I suggested to the former Minister of Justice that it raised very important questions about transparency and the need to address issues of conflict of interest, and thought it would be appropriate for there to be a reference to the Law Commission to look at the issue. And the Law Commission, under the chairmanship of Sir Grant Hammond, a former judge of the Court of Appeal, produced a document. It gave rise to a lot of discussion, not only in the profession, but in the general community. But the consensus was that the better approach was to have guidelines on recusal. And so when the former Minister of Justice again asked the Law Commission to look at reforming the Judicature Act 1908 and at the same time have a look at the Supreme Court Act 2003 and the District Courts Act of 1947 with a view to a rewrite of those pieces of legislation, the Law Commission produced a very good report, and that has formed the basis of what now sits on the order paper awaiting its second reading as the Judicature Modernisation Bill. And one of the recommendations of the Law Commission was that it be incumbent on the heads of bench to provide guidelines on the issue of recusal. And that applies to the Supreme Court, i.e. the Chief Justice, the President of the Court of Appeal, the Chief High Court Judge and the Chief District Court Judge. Very clear guidelines are required because, and I know Sir Grant Hammond won't mind my saying this, he's actually done a lot of work over the years on the, if you like, the law of recusal, and he said during his time as a judge he'd always be getting questions from judges about whether or not they should recuse themselves, because it's one thing to set down the principles, but it's the application of those principles that can sometimes be very difficult. So that legislation that I hope we'll be able to debate in the reasonably near future deals with precisely that issue, and it's not lightly touched over, or it's not done in a slapdash way, but it's responding very carefully to what the Law Commission recommended and to what submissions made to the Select Committee have suggested. And while I didn't sit on the Select Committee, I don't think I'm wrong when I say almost overwhelmingly submissions which were made to the committee were opposed to the concept of a register of pecuniary interests for judges. And I refer in particular to the very helpful submissions by the New Zealand Law Society and the New Zealand Bar Association. I understand that the judges also made a submission, but they did not wish to be heard on it. But the important submission that was made by the Law Society traversed a number of areas, but particularly mentioned, as indeed did the Bar Association submission, the difficulties that there could be with recruitment of judges, and I believe that's a very important matter. As the Attorney-General, I'm responsible for recommending to the Governor-General the appointment of judges, and there are protocols which are set out and are published on the Ministry of Justice website as to the way in which I do it, and I have to consult with the Honourable David Parker, the Shadow Attorney-General, on senior court appointments, and often have discussions with him on these issues, and he with me when I was the Shadow Attorney. These things are very important. We have to make sure that all sides of the House accept that an appointment is an appropriate one. We can't possibly have what happened in Queensland a couple of months ago, where someone was appointed who did not meet the favour of the judges, and when he came to be sworn in, none of the judges turned up, so it was a pretty lonely swearing in. So appointment of judges is incredibly important, and we need to go out and get the very best people that are available to enter public life and serve their country in the judiciary, and it's no easy task. On Friday, I'm going to speak at the swearing-in of a person who has been appointed to the High Court after 20 years at the bar, and before that a number of years in a commercial law firm. Getting high-quality people on the bench, as Mr Parker would agree were he here, is an incredibly important issue. And so what we do not want is anything that could act as a chilling effect on the appointment of judges, and I strongly believe that if there were to be a register of pecuniary interests, it would act as a very, very chilling effect on the appointment of judges. And I know how judges come under attack all the time. There are cases in the system at the moment where a person appears before a judge, they're dissatisfied with the result, they complain to the Judicial Conduct Authority, they make the most dreadful allegations against judges. When they don't get what they want from the Judicial Conduct Authority, they go back to court and seek judicial review of that person. Judges more than ever are under attack, and it's incumbent on us to recognise the separate branch of government that is the judiciary and protect them from unwanted criticism. That is not to say that they don't have obligations to uphold our great traditions of justice and uphold the principle that justice should not only be done, but it should be seen to be done. And that is why I am so in favour of guidelines dealing with recusal. So, Mr Speaker, I frankly congratulate the Honourable Member on bringing this bill to the House. I think it does raise, as Ms Ardern said, very important constitutional questions. And that's the great benefit of Members' Day, that sometimes we get an opportunity to discuss these matters. But I say to him with respect, I think he's got the wrong end of the stick. I think that this is the wrong approach. Rather than deal with a registry of pecuniary interests or a register, we should be dealing with or making sure that the judicature modernisation legislation has that obligation on the heads of bench to introduce guidelines on recusal.